I guess that's sort of why I got brought into the cabinet. Yeah, but I wouldn't say it's necessarily my main focus.
Okay. Hey Nino, I watched that YouTube video last night.
Which one?
Veritusian?
Oh yeah. What'd you think of it?
It was interesting.
Yeah.
Made sense. You know, one of the first things I thought off the bat is like the totals of both were uneven. One of my first questions would have been like, well, are the remainders no change at all? Because the only two options are better or worsen.
Oh yeah, that is true.
Yeah.
Yeah, the video, it's so applicable to so many things. I feel like it's common sense, but it's one of those things where it's common sense, but until you point at it and throw research behind it, like I don't know, it stands taller that way. Okay, so
I also took a look at those cases last night.
okay.
I mean, these are both stemming from what could be considered, because this word's getting thrown around, exigent circumstances where the police are, well, the Kyle Pred one, they had found an unreported gun for the 10th time or the 4th time or something like that, and they got a raid, and then basically they're connecting him to every single piece of crime that's connected to any item in the warehouse. I really can't speak to anything about a marijuana operation going, but the fruit of the poisonous tree would have to start before, because that would be in plain sight. Some things I would say are argued like, no, the plain sight more so applies to the Hydra case, where they watch the individual run in there.
Yeah, so the interesting thing about the Pred one is that a lot of those weapons that were found were from months ago, and he didn't have a gun license for 3 months, and he had only just gotten it back. And in the warrant that was issued, they reference 10 guns, but they don't actually note what those 10 guns are, right? They just say that they exist, right? And it's a very much a trust me, bro. Following that, oh, hey, princess, how you doing?
Hello, I wasn't expecting you to be the one pushing pills at the police department.
Huh?
Wait.
The man over there told me that someone was across the street pushing pills, so I went across the street and it's you guys.
Oh, what? No, we're not pushing pills.
Oh, well, then I don't know who he was talking about.
It's probably a metaphor.
Yeah.
You think so? Oh, by the way, Nino, a man named Metro Man wants to kill you.
Oh, yeah, he came up to me and I think he threatened me, and then he realized it's probably not a good idea.
Yes, he asked me if I would behead you.
What the fuck?
Yeah, that guy called me. I talked him out of it.
Oh,
that's
really?
Lovely. When was this? Because I talked to him right before the weather change, and he told me he was going to kill the mayor.
Kind of right before the weather changed. Like
all right.
Oh, Jesus Christ.
Mine was probably after yours. I don't know. He seems crazy.
Yeah.
Anyway, I will let you get back to this.
Hey.
I want to find who's pushing pills on my block. I am MRPD official pusher.
Oh. Holy shit. All right.
Okay.
Okay.
So, the warrant that they use to raid Pred, it references 10 weapons, but there's no indication that those 10 weapons exist. The second is they make the claim that Pred was documented to have 2 very specific weapons, the two 1911s, and they list out the serial number. And they say one of those was recovered, allegedly not reported, but they're assuming the second one was sold, even though there's no knowledge or existence of what it is, what happened to it, etc. and he is well within his rights to dispose of that weapon as he pleases, right? You're not legally obligated. In theory, you could go and take that gun and throw it into the water, right? And you no longer have it in your possession. No one, like, obviously someone could get it, but it's not like he can't do that, right? And there's a
Michael
number
found a
of
gun
other
in that
things.
water last week.
Exactly. Yep. And then
Also,
so they never really, and then they say because of that they have probable cause, but the argument is for criminal negligence of a firearm and not stockpiling. But then when they actually list everything out, it's listing like 6 different things that they want PC for. It's kind of a shit show.
I
Right,
feel like
yeah,
a lot of this is built on assumptions and not actually probable cause. Like they're assuming he sold the weapon, blah blah blah. Like,
well,
I don't know.
the language is also transfer. It doesn't even need to be a sale. But you're supposed to report it as kind of the gist of it, and if they find it, quote unquote, stockpiled somewhere, et cetera.
Yep.
One thing that stuck out to me though is statute of limitations applies to both charges and evidence. It appears.
Yeah, so that's another thing that's extremely odd, and there's other things that I don't want to mention but will come out in trial since it's client attorney information. But they I will die on the notion that the statute of limitation that references that the statute of limitation begins when evidence that was not otherwise discoverable became discoverable, that the statute begins then. I do not in a million years believe that that was intended for this shit. And the fact that they're using it for criminal negligence of a firearm is insane, because I'm very familiar with the long-standing conversation that lawyers, judges, police had around like serial killers, murders, shit like that. And that's what that shit was for, very long running. Like, let's say someone bombed the Pixel Tower, right, in an act of terrorism. And, it'd be very odd if on the 31st day he came out and was like, I bombed the building. You know what I mean? Now, that is what it's meant for. I will die on a fucking stake that that's what it's for. But the way that they're trying to make the argument that it's for weapons that they haven't come across is asinine, because if you start to use that standard, well, then you can use it for literally every single crime in Los Santos.
Yeah, it additionally says in the statute legislation, when they do select something outside that 30-day scope, they are subject to provide an explanation and justification as to why it's being done, and that explanation is subject to an additional review, which I guess would be upon request, which I guess would be the issue for his lawyer to pre-trial motion or hearing for that, or meeting with the judge or something.
Yeah.
Honestly, we have a lot of laws and policies that I think are just like basic violations of rights, to be honest. Like, look at like hot gun laws. Like, you're telling me just because someone has a gun that was used in a crime, like they're suddenly guilty of it without any surrounding evidence supporting that? Like, that's crazy.
Yeah, it's...
well, it depends if they're trying to say it's an accessory charge and whatnot. And a lot of these charges on Prez things should say accessory without any actual probable cause that he was there with them.
Yeah, I mean, hot gun charges aren't really relevant to this, but like, there's a lot of weird stuff that like I think gets kind of abused by various people.
Oh, Serenade. Yep. How you doing, Serenade?
Hello.
Sorry if I'm a little late.
No, you're good. So
Serenade.
Yep.
Nice to meet you.
Is so
You as well.
do we want
Abilene Contralto.
Oh, Adam. Okay.
let's actually take a moment, because I know Abilene and Maeve, you've also only just met. Do you want to give each other, like, let's do like brief introductions so everyone's kind of familiar with each other. Starting with you, Abilene.
Hi. Eve and Saren, Abilene Contralto. I've been an attorney in the city for since April. I've just kind of been doing my thing, cases here and there. A few months ago, I got picked up to join Mr. Chavez's campaign as a assistant legislator and attorney, and also an internal role of attorney general. Something that we're kind of considering, I guess, one day implementing. I don't really know. Got any questions for me? Feel free. I'm just kind of an attorney.
Abilene's done a lot when it comes to our early legislation that was putting in place, both in terms of review, writing, etc., or giving like legal advice.
Okay.
Yep.
All right. Well, glad to have you on the team.
Oh yeah.
It's good to meet you.
Yeah, I've heard good things.
Maeve?
Yeah,
Sorry, were you gonna say something, Sarah?
I was just gonna say I look forward to working with you.
Absolutely, you too.
Hi, I'm Maeve. Maeve O'Hara. I've been in the city like 8-9 months now. Started as a private practicing therapist. Did that for a while. 4 months or so. Worked in dispatch for a little bit. And was kind of in limbo after that. Had a meeting with Nino a couple weeks ago about the Psych Act and some concerns I had with it, and he offered me a position in the cabinet. So I've just been here for the last couple weeks, still kind of getting the hang of things. But I guess I'm here more to provide like a civilian insight, perhaps. And yeah.
Wonderful.
Yeah.
Okay. Hell yeah.
I'm sure your knowledge and experience is going to be fairly invaluable.
Okay.
Is it my turn now?
Yep. Yeah, go ahead.
I believe so.
My name is Saren Aid. I've been a practicing attorney for many years now, and formerly a judge. I had a tenure of about, I think, 10 or 11 months. So it was quite some time. Actually, it was not quite 10, but, and, after a hiatus, I kind of put my feet up on a number of different beaches. I kind of, I'm back here practicing law, and ran into Nino here after a couple discussions, kind of came on board in more of an advisory role.
Yep.
And yeah, that's where I'm at right now.
Yep.
Working on a number of pieces of legislation.
So,
Well, that's awesome. I'm glad your expertise is here. I look forward to, if we collab or work on anything together. Fun.
Yep.
Absolutely.
All right.
I'd love your feedback on the things I'm working on. Currently working on LAP and a mashup of two different pieces of legislation. One was written by Michael, and the other by myself.
Twitch is having a bad day in the Netherlands, apparently. Wait, really?
Also, I'm reworking the attorney classification.
Wasn't that written by the DOJ?
Yes.
So you're testing it?
I'm working on basically an amendment to it. Really, it's taking the bare bones of it and expanding on things, as well as one of the goals is to provide a little bit more defined protections in terms of like client confidentiality, protections for legal aids, paralegals as well. When they're operating and acting on behalf of a supervising attorney, because really there isn't any protections if they're not, or really any outline protections at all at the moment.
Fair enough, makes sense.
Yeah, protections for lawyers and attorneys and legal aids. I'm always all for that. I wish you the best of luck. Just submitting it in amendment form. That's a little ballsy, but I guess we'll see how that goes.
Yeah.
Well, there are a couple of avenues we can go about doing this with. One, we can work with both mayoral offices to try and push it through that way, or we can go the amendment route, audit route, I guess, through the state legislation and through the DOJ itself.
Awesome. If you need any help, assistance, want to talk about that, feel free.
Sure. I believe it should be accessible already for you to review.
On the Trello? Okay, if it's on the Trello, I'll check it out tonight then. I look at my Trello.
Yeah, that's about what I've got going on at the moment.
Okay. Hell yeah. We were just discussing the cases that Abilene was looking at, given that they're rather big ones. And that sort of stemmed into the conversation regarding the statute of limitations. In the case of Pred, there's information that they're trying to encircle. As a part of writing that warrant, they encircled in evidence that was found more than 30 days ago. But because... So there's a line in the statute of limitation that says that evidence that wasn't previously discoverable becomes discovered. The statute of limitation begins then. So like, let's say you sold a gun 90 days ago to someone illegally, or allegedly, I should say, but then that weapon got found by the PD 90 days later. They're claiming that the statute is applicable in that case. My general argument it is not. That instead that exception was, in my opinion, meant and intended for like bigger crimes. For example, someone blowing up the Pixel Tower, and then on the 31st day, with no evidence left behind, and then on the 31st day, they're like, yes, I did it. I blew up that tower, and here's like the detonator. You know,
I'm certainly not a lawyer, so correct me if I'm stupid. But I feel like there's two key things in that. One, wouldn't they have to like be able to prove a time frame of like which the gun was like being sold and stuff? And two, like, if hold on, give me a second to figure out how I want to phrase this. Now that's a train of thought. Repeat what you just said.
So, here, actually, I'll pull up the actual legislation.
And then keep in mind, I believe we're talking about the criminal negligent ownership of the firearm charge specifically, or what, just so
yeah, kind of. Like, so I'll give you the legislation and what we believe is being used. It is... statute of limitation legislation. In there is something called, in Section 5, delayed discovery rule, which says subject to judicial discretion, if a crime or basis for civil action is discovered after its commission and was not initially detectable, the statute of limitation shall commence from the date of discovery.
That was my second point.
Provided that substantial evidence supports it. Yeah.
So discoverable is something coming to light, right? But if they're, doing their jobs of tracking, firearm registries and everything, shouldn't that information have been discoverable? They just weren't actually doing the legwork.
Exactly.
To have a record.
They already had these reports. Like they kept getting pinged over the months of stuff, and
it was discoverable. Yeah. They just didn't discover it.
They didn't act on it. Exactly.
Yep. Exactly. And so now I don't particularly believe that this has been highlighted in the case, but the fact that they're referencing going back to the way that the warrant was written, they're making the claim without any evidence that Pred had two 1911s and that they recorded the serial number, right? They don't provide a date timestamp. They're saying he had those months ago. And of one of those allegedly documented weapons, it then found its way into the hands of someone else, and that it was unreported. And therefore, they are saying that the second weapon probably was also sold. So they may not have even gone this far, right? Like to make the argument that it's within, that it wasn't discoverable before. But the fact is that it's so, honestly, the entire warrant is so convoluted that I don't even know how the fuck it stuck to begin with. So it's like, they're saying, oh, he had 10 guns before that were recovered, but we're not going to give the report numbers. And, oh, trust me, bro, we documented these 2 weapons on him, one of them which was stolen. So probably, trust me, bro, he probably sold the other one. And therefore, you know, we need a raid warrant. It's actually insane.
I mean, at least with how you're presenting this to us, like, this seems incredibly flimsy on their end. Like,
it is. Yep.
Their definition of discoverable is already fucked. I mean, they have no dates or documentation or serial numbers written down for 8 of the 10 weapons, from what you said. Like,
correct.
They haven't done their due diligence.
Yep. And like, at minimum, and the problem is that because, like, let's say these things were documented, you would expect that there would be report numbers, so like an attorney could scrutinize the claims made in the warrant. But because it's like 90% trust me, bro, how it got signed is a mystery.
We don't know anything about that.
Yep, exactly. And it is to date the worst warrant that I have ever read that has gotten signed. Even the language and the flow of the document so they start with, like, I'll describe it this way. They start with a premise. They then come to a conclusion that they have reached probable cause, but they actually don't. But then open up a brand new premise and expect the reader to assume that that's part of their original argument for PC. So, and that's notwithstanding all the other points that I brought up. It's very odd. Like, so, it's the right, and oh, it gets worse. The phone subpoena and bank records, which typically would be sought prior to a raid warrant to help establish things like, when were the sales? Were there any communication regarding was done post facto? And in those warrants, they actually took the original language in the raid warrant and redid everything. Because
It feels like nearly everything was done post facto. Like,
yes,
they did the raid and then they did the investigation.
Yeah. Yep. It's the breadcrumbs of a come to a conclusion and work backwards. And this is notwithstanding that on the docket itself, as we had believed for 2 weeks coming up to it, that it was so strange that his apartment didn't get raided and then mysteriously the warehouse did, which he had only had in his possession for a total of like 8 hours, 6 to 8. How did that get raided? Not the apartment. Why a night raid? Why not raid the place where the weapons would have been found? Is that they were expecting weed. And we're like, they must have known this was a weed warehouse. Well, lo and behold, we learn from Sonia Summers that she had it and may have been using it for that. And finally, the marshal that took on the case as the prosecutor kept trying to prevent the defense from getting access to this information. Finally, the interrogation comes out the day of the raid, in which a marshal states that they knew that Sonia was operating out of this warehouse for a long time, to the extent of naming people that she was believed to be selling drugs to. So, like, it's so dastardly, so corrupt. It's shocking that this is even happening and that the case is still open, and that no one internal to that investigation's like, guys, this entire thing is fucked.
I mean, like, the thing is like, is it possible that Pred was doing shady shit with his guns or knew that weed was in there? Sure. Is it likely? Maybe, yeah. But they still have to be able to prove it, and they haven't put forth the effort for that.
Yep. Yep. So, but so I want to sort of circle back to what we're working on right now. I know we're probably going to see that court case continue this weekend. From what I've seen, it looks like he's trying to schedule for then. We'll keep a close eye on it.
Tomorrow, or did that get moved?
I think there was a hearing last Wednesday. No, oh no, on Saturday. Unless there was an update to the docket.
I thought there was a hearing tomorrow, unless it got moved.
Let me take a look.
Wednesday, November 20th at 8 p.m. No, they pushed it to Saturday at 5, I think. Yeah, Saturday at 5, I guess, is the hearing.
Oh, I see it now. Oh no, Sparky's got perjury coming his way. Oh man, that's gonna be juicy. I kind of want to help him with that.
Speaking of dockets, have we gotten any progression at all on our contest?
Yeah, Saturday 5 p.m. No, I did speak to Hollow, and I'm gonna probably just reach out to the governor, to be honest, because I've been kind of playing the like, it's not my responsibility game, but like, you know, I'll go see what's up.
Yeah, I looked to see if there was any traction on that at all, and just didn't see anything. So I assumed that there was some sort of holdup.
Mm-hmm.
Have we gotten acknowledgement that they were received?
Yes, they have been received.
Okay.
Yeah, it's on like a laundry list of pending things, I guess. So my impression is that it hasn't even been remotely looked at, because when I spoke to Hollow, he was like, which audit? Or like, it was like, oh, I was like, you know, the
That's reassuring.
thing from the state officials, and he said, which one? And I'm like, huh? Right? I as a licensed psychologist in training, I read that as I'm aware of it, but I'm going to pretend that there's a series of other things that have been requested from the state officials to make it seem like we've got more on our plate than we actually do, and are more busy than I'm going to allude to in this conversation. I haven't actually read it, and I'm coming up with an excuse, because I'm sure there's other things that have come to them from state officials, but common sense would dictate which thing I'm referencing specifically, given it's the one that the mayors are referencing. You know what I mean? Like,
Yeah.
Concerning, to say the least.
Yeah.
I mean, we've talked about this in past meetings. Like, we need to be able to do our jobs, and like right now we can't. So, I mean, there are some things we can do, but as far as legislation or anything like that goes, like, we're, you know, sitting ducks. Like,
well, it's the equivalent to what happens in U.S. government when entire set of representatives and congressmen and whatever decide to take vacations timely around like conversation. This is what's happening. The it's convenient LOA. You know what I mean? So.
I mean, if people need to take LOAs, they need to take LOAs, but like we should be able to then, like after a reasonable amount of time without them, move forward without them if that's the case.
Yep, and I think this is a good argument to be made. I think what this is going to lean towards is I think the recommendations we had up is that we should put a clause in that after 2 weeks of immobility, it immediately goes into a referendum or something along those lines. So I think if anything, while it's unfortunate, I always look for the diamonds in the bullshit. You know what I mean? To me, what we're discovering is a hole in procedure, which can be resolved. Like now that it's come to light, we have evidence of what can happen. And, we can now push for procedure around it. And I think that's actually a good one. Where if something does not make lateral movement in 7 days, fuck 2 weeks, in 7 days, it goes to referendum immediately.
I feel like this is just further proof that like the system shouldn't be wholly reliant on like 1 to 3 people being present and capable of doing their jobs, because like it's not fair for like us as an office and for the people we represent, but it's also not fair to those 1 to 3 people to have everything resting on their shoulders to make sure we have a functioning government.
Yep, agreed.
That's too much work for one person.
Yep, absolutely agreed. So, I'm gonna work on the marijuana dispensary and cultivation guidelines today. I've kept it very short. It really, right now, just says when you're transporting marijuana and paraphernalia, you should document and photo the contents of the vehicle before departure. 311 with a date, time zone, and include your location, destination. Oh, excuse me, my my phone's messing with me. Location, destination, amount being moved, primary driver, and to take a photo of the 311 with a date and timestamp. And then I noted documenting transactions. All transactions should be documented, and inventory should be recorded as close to weekly as possible. At the top, I write, these guidelines are written to help assist dispensary, cultivation facilities, law enforcement, and the Department of Justice to ensure alignment, to ensure smooth operation within the bounds of the law. I'm going to actually put another line in here. These are guidelines, not law.
SOPs.
If any party has suggestions and alterations to these guidelines, suggestions, additions, and alterations to these guidelines, please ensure, please send them to the Los Santos Mayor's office, and we will adjust as needed.
Good. We'll have flexibility.
Yep. Agreed.
The document to which you're referring, is this in the Trello? Because the one in the Trello is just a spreadsheet.
Nope, you can see it if you click on reports. You'll see it at the top called Marijuana Dispensary and Cultivation Guidelines. And it has like you'll see it under Los Santos County documents.
Because I had thought we had written up a whole bunch of, well, even myself and you and Michael, didn't we do a big, huge, extensive like thing on this? Or is this for the cultivation aspect?
I don't think we did. Did we?
Well, let me just check something before I speak to you.
I don't think we did.
Los Santos County cultivation facility legislation.
So that's, oh yeah, yeah. So both the marijuana cultivation and dispensary stuff has been passed. However, the guidelines document are like SOPs. You know what I mean?
I see. Yeah.
Yeah.
Okay. We discussed that
Yep. So,
aspect with me before. Now I.
yep, exactly. So the SOPs are there, and as an example, right? I don't want to see law enforcement use cultivation and dispensaries to like content farm or whatever you want to call it, where they're like harassing these new businesses just to like find a reason to raid them, which unfortunately is culturally acceptable. Evidence being Kyle Pred. And so this sort of serves as a way to assist them while simultaneously assisting law enforcement, right? So the 311 is a great way to say, hey, we're moving this. So if that driver gets pulled over, they can reference the 311 and, hey, this is all Gucci. Simultaneously, it helps them and law enforcement in the event someone tries to rob one of these transports. Among other things, right? So, this is, the dispensaries and cultivation do not need to follow these, as it is simply guidelines, but it's sort of like a way to say like, hey, we believe that this is how you should do it. Yo, Prince Kavera, think of the 5 months.
Yeah, I mean, ultimately, the more documentation they can create to protect themselves, the better.
Mm-hmm. Yep, absolutely.
Yeah.
Liability. I do want to add to this that I put together a form that is only going to be given to cultivation and dispensaries. In it, they are able to select from the drop down like their business and along with the owner of the business, and then they can do like add property, add employee, remove property. And the idea behind it is it creates an audit log of time date of when these actions have taken place. And so law enforcement will be able to see like a view of every dispensary and cultivation location and all the active employees with an audit log, so that people cannot falsely claim who they are, but at the same time, actual employees can protect themselves when conducting business.
I do like that.
Yeah. Yep. I was kind of like balancing their privacy, and technically this isn't needed, but we're like pushing it. You know what I mean? Like, this is for their own protection more than anything else. Like, that's how I kind of look at it, because I'm gonna be honest with you. That's my biggest fear, is someone gets bored, cop gets bored, and they're like, let me start finding something I believe to be a technicality, and let me try to shut this place down before they even have an opportunity to kind of like kick off their business.
Well, not only does it help protect against like officer maliciousness, potentially it helps prevent against, just ignorance as well. If they don't know that someone is a, licensed distributor or whatever, it just keeps everyone safer.
I agree.
It also prevents the police from the requirement of issuing a subpoena, which could reveal other information you don't want to reveal, where this would be sort of public information, not if I'm assuming that correctly, right?
Yep,
so if
that
they're
is
worried
correct.
about the logged transactions, they don't have to go, oh, we want a subpoena to search all the records and then find a bunch of extra stuff. It's like, no, here it is in a neat pile of the relevant information.
Yep, absolutely. All right. Okay. Well,
I do think it's a good thing that we're trying to get ahead and tackle these issues before they kind of pop up. I'm not sure, Mr. Chavez, of your involvement in anything in the past, but in my tenure as a judge, I did see a number of cases coming from officers attempting to go with technicalities and bring people to court, specifically employees of dispensaries and whatnot. So
Yeah, I'm very familiar with some of those things.
Okay.
Yeah, there was one person in particular that comes to mind, but there's a lot of those nowadays. Actually, I would say that there was one person in particular which I personally never had an issue with, but there's a lot of carbon copies that like do 1% of that job. So,
Yeah.
you know,
I mean, I think it's sort of like the same standard of like, cops get told, for instance, write your paperwork as if it's going to court, even if you think it's not, because like you have to think about it from like how could a lawyer try and poke holes in this, right? Like that's a good training standard for them. We as legislators need to kind of apply the same standard to what we're producing, and how can this be exploited by cops, by criminals? How can this potentially be misused or misinterpreted, and
Yep.
try and prevent that as best we can.
Absolutely. All right. Okay, well, I am going to start cooking on this. Is there anything else we want to kind of bring up? I think it's going to be, generally speaking, I think things are going to kind of be on idle for a little while we figure out what's going on with the DOJ. And I'm going to be kind of chilling out over the next, week, personally, just to kind of regain my energy for when the engine kicks back off. So...
I'll just continue working on my projects. Did any of them need to be expedited?
I don't think so. Not really. I think we can kind of do it at a... I think it would be worth trying to get something up, early. Earlier than would be good in general. But, I'm not in a rush. I'm not in a rush, but getting it up there would be good in general. Just, so people can see it.
I wouldn't stress out over it because, without the DOJ around, it's not going to immediately pass or anything, even if you got it up there in the next 5 minutes, anyways.
Yeah.
But
Yeah,
Yep.
I just wanted to, ascertain how y'all were kind of processing things. As I'm kind of in and out, right? Most of the time, I can't make these meetings, so.
Yeah, no worries.
Just wanted to know.
Yeah, I would say the value of getting it up early is it substantiates our point that things are at a standstill. You know what I mean?
Mm-hmm.
So I feel like Clap is not too far from a shippable product, and the same with the lawyer reclassification amendments. So.
Good.
Also, FYI, I will not be here tomorrow afternoon. Appointment.
Okay. Understandable.
Oh, Nino, did we make any progress on that press conference? Is there anything we need to do to...
Oh, yeah, that's right. I was going to do it, and then I was just like... I kind of feel like, you know where it stands? Is it kind of feels as though we've been screaming at the sky, and I'm going to shoot straight. The behavior that we're witnessing is so egregious, but optically it may come across as us being toxic towards the DOJ despite us being in the right. And that's why I've been holding back.
Yeah, well, and I think that's the comment I made on the notes we were prepping is I want to make sure we're not focusing on, well, the DOJ isn't blah, 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 but keep it on this is what we're accomplishing and what we're trying to do. And this is their status, and that we are working on stuff and not just sitting idly by.
Yeah, it's like perception can be a bitch, right? And it's kind of like while factually we've been fucked for God knows how long, and it's while we may recognize that there is sort of a collective tantrum being thrown to say no. The thing is that drilling the point even further can easily just be manipulated. We put, I don't know if it's going to be beneficial for us pointing at it, because even if, let me roll back. Even if we had a press conference and we're like, here's what's going on, and even if it was done in a way not to point fingers, we will be asked questions that will result in us pointing fingers, right? So that's been the battle in my mind. Like,
yeah, I agree with your struggle because I have similar sentiments. Like, wow, how much we want to, there's all these other factors.
yeah. So I feel like I kind of realize that it's more productive for me to just go to the governor and be like, here's what we've done. These people have been MIA. Maybe we need something sooner. So I don't know.
Yeah.
I'm gonna figure out what it is. But yeah,
I'm sorry, who's the governor?
Mr. K. Oil.
Oh,
He signed the Constitution. Yeah.
got it.
So it's one of those, like I said, I've been on a holding pattern. I know I had been in some communication with him. And there's things that were planned, but I'll see if I can get an update. You know what I mean? I'd rather not spend our eternity just being like, fuck the DOJ, fuck the DOJ, fuck the DOJ, even though we're in the right. Even if we're in the right? But at this point...
Sorry, go ahead.
At this point, I don't want us to end up being a broken record when there is other avenues we can take as well.
Yeah, I get that it feels like a broken record for us because we talk about it every day. But basically every single person I have talked to where like something like FOIAs or something has come up, right, has no idea that we are working on or doing anything, and basically feels like abandoned by the government because it's like, well, everything sucks now, so it is what it is. And it's like, well, we're working on this, we're working on that, like we've submitted this, we're brainstorming about this, and then like that seems to help them feel a bit better. So I think it's less about pointing fingers at the DOJ and more about giving people a reason not to doom spiral,
Yeah, I'm agree with you 100%. I just don't know how to do that without a press conference that will ultimately lead to us saying the DOJ abandoned you for the last 3 weeks. And it has resulted in the entire government being stalled because they wanted ultimate power. And they were told no.
We can circumvent with careful phrasing, but I think the key thing is that even if we ended up having to point out a problem, that we also provide our solution or our idea on how we can come to a solution as well, so that it's not just, well, the DOJ fucked off. It's like, well, yes, the DOJ hasn't currently responded to what we've submitted, but we are still working on ideas to blah 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 blah, and we've done blah 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 to try and prevent this, etc., so that we can shift the focus away from the fact that it's DOJ isn't here and more on here's what we're doing.
The problem is, what can we do? That's the issue, right? Because the reality. So let's say, I think in principle, I would agree with you, but my problem is when you say here's what we are gonna do, what can we do? We don't even have an answer for that other than fuck the DOJ. Like,
do you think it might be beneficial to selectively share and bring on, at least in a cooperative manner, some of the judges that are more available to the people?
Well, to ensure that my concern is a little bit on the nose, so I agree with the principle that people are going to feel like the government has abandoned them, which they have, right? While we haven't, the rest has. I can't think of a single thing that we have been doing to circumvent this because we don't have the facility to without their signatures. And it's not like we have done anything to have caused this other than pop their bubble. You know what I mean? So I guess what I'm trying to say is I don't know what I would respond to in regards to what is it that we have been doing. You know, I feel like we'd have to lie to the public on behalf of the DOJ to reach that conclusion. To give them the answer of like, what have we been doing in the interim?
We have come up with a new legislative process to bring to the table. We have contested the Angel and DOC and PDLEO acts. Like, yes, those are things that require them to come to the table, but also it does require a level of state oversight. I mean, we are working on things that are, you know, hoping to rectify these solutions.
I see what you're saying. Yeah. Yeah. You're right.
We, you know,
Yeah.
FOIAs, etc. Like we're reviewing the penal code. I mean, we're doing all sorts of things to audit the government and make sure that it is functioning in the people's best interests. Yes, it is frustrating that the DOJ is not present and participating in these conversations, but we are working to do so, and we're not doing so in a way that's solidifying power for our office, but trying to ensure that everything is fair for every branch and for the people.
Yeah.
So, kind of piggybacking off of that, one of the reasons why I brought up potentially bringing on some of the more publicly available.
The problem is we do that, we're going to have to say DOJ's absent.
It might be an
and they're on
branch
LOA.
to the DOJ.
Now, the moment someone asks a question about it,
kind of persuade the public opinion of things, we can kind of push our side of it, as well as, I would say, is it really propping up specific judges? So that way the DOJ doesn't necessarily take the full brunt of it, and they get to save some face, and we get to move forward.
Well,
can you clarify propping up a judge in your context?
Well, not just a particular judge, but, well, so it seems to me like we're saying if we do this right and we don't do it correctly, it'll come across as we're just kind of beating a dead horse, the dead horse being the DOJ, right?
Well, and more specifically, the justices and their clear lack of care, which I think is ultimately, are we ready to once again publicly shame the justices? Because that is ultimately where the conversation is going to end up going.
Here's the thing, just an outlook of it. I mean, this campaign originally started in its first term with a path and goals, and that path and goals, nowhere, you know, I don't think we ever theoretically said, yes, toiling endlessly with the DOJ is our path. Like, we're completely, you know, it completely saps the energy of stuff we could be doing, and Nino knows that more than anyone. So I think it's really also about, do something like that and they want to play rough. Is it going to draw us down into a nonstop quagmire like it kind of briefly did during the first term?
Oh, it never stopped, I believe.
I'm trying to
be pragmatic.
Yeah.
No, I'm with you. It's kind of like, I'm going to give you my, I want to like kind of give you my perspective kind of one more time. And is like, I really want to do this press conference and I do want to explain what it is that we're doing. But I know from the moment we're asked any specifics, it's going to be like Angel, Hart, and what's his name? Hollow have virtually disappeared over the last 3 weeks. The moment we challenged their authority to do whatever the fuck they wanted, and they took their toys and they went home. And
so I don't think bringing attention to that fact is necessarily a bad thing. They are, at the end of the day, public servants, and we are, at the end of the day, drafting articles of impeachment potentially because they are not fulfilling their duty, and the public deserves to know that. I think the key thing is how we phrase it. So rather than, you know, they threw a fit because blah, 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 they took their toys and they went home, we say, you know, we have submitted these things at this time, the DOJ has remained unresponsive. There are diplomatic ways of saying it, that can get the message across without being overly toxic, and that can still apply some pressure to the DOJ, maybe in the eyes of public opinion, to get their acts together.
I agree, but then what happens when someone asks the question, well, why did they disappear?
We're not the DOJ. We can't answer for that.
But we know the answer.
Do we?
Yeah.
Well, I mean, technically, we are assuming the answer.
Yeah, but see that right there is where it hits the principled side of me, is like, I don't want to lie to the public. Because we know why they left. At least I feel like I do.
I don't think that's a lie, really.
Yeah.
But, I see what you're saying.
Yeah. That's the conundrum that I cannot, like resolve in my mind.
They're on a pedestal of power, and here comes someone who's shaking the pedestal. And they said, well, rather than just stand on this, let's get off of it, go away, wait till they stop shaking it, and then we'll just stand back on it.
Yeah.
I think, if that's a question that comes up, I think it's, the DOJ has remained unresponsive at this time. Well, why? That's an excellent question for the DOJ. It's not one, we're particularly ready or able to answer, but we remain committed to coming to the table and working with them towards solutions for these issues.
Yeah, let me cook on this. I'm not saying no to it. I just I need to be prepared myself.
No, absolutely.
So I am going to try to try to communicate with the government and see what they come back with. But I think this is a bigger issue than we can necessarily solve within the city.
Meantime, I can try and reach out to some of the more available judges to kind of scope out how they feel on things, their thought processes.
Yeah, I think let's hold on this until I get a better answer from the top. Like I said,
maybe maybe I'm being sentimental or something.
Yeah,
former judge trying to go through avenues that are not necessarily beneficial just because of my history.
Yeah, exactly. What I'm trying to say here is that I think this pimple has gone so big that there's a rupture that goes beyond us that may be at play. So, that's why I'm sort of like, if it feels like I'm trying to avoid this topic to a degree, I am. But it's hard for me to express the details.
You're good.
Yeah. So.
Aaron, are you on the lemon list by chance?
Not at the moment. Hang on.
What I'm trying to say is, I don't think you can just RP this out.
Thanks.
So, listen, man, I'm down. Yeah, I'll explain.
That was me.
I don't believe this can be RP'd out.
And Maeve, you are right.
Yes, I do.
Exactly. We've been trying to RP it out for the last 2 weeks. And, realistically, okay. All right. I'm going to get cooking here. Please do reach me if you need me. And I'm going to think on this very topic. See what our next steps are.
Yeah.
All right.
Let me know.
All right.
Yeah,
I appreciate it, guys.
Same thing if you need any.
Will do.
Ad hoc, or at the moment, just email me.
I appreciate that.